We want to further to tell you that the DPP is interested in abuse of the legal process, is to talk about the jurisdiction. Your Honor, when I talk about jurisdiction, you remember the famous case of the late Mr. Albert Ojwang, which is very much related to this case that we are having today. That Mr. Ojwang, Your Honor, was picked from his home in Homa Bay, moved to Nairobi at Central Police Station, and killed in the cells. Your Honor, there is no any special gazettement, or rather the gazette notice by the Chief Justice to gazette this honorable court as a terrorist court. So any magistrate in the country can deal with this matter. And to tell you that the DPP is interested in wasting the court's time and the public resources, that they had to move. They saw it fit that Oyugi's law courts was not fit to handle such a matter. And you know, Your Honor, that the only courts that are exempted could be the anti-corruption courts, ELC, and the children's courts, because they have special jurisdiction. But otherwise, any other court could have handled this matter. Your Honor, terrorism is an ordinary crime that can be heard by any magistrate. And there is no special prosecutor that is assigned the special duties to handle, or rather to prosecute terrorism. Any prosecutor can do it from any part of this country. So we ask ourselves that what is the malice and what is so special in this case that we had to move our clients, law-abiding citizens, whose only mistakes are to fish and transport that fish using a border to the markets. Border riders and the fishermen. Your Honor, this is clearly what we state as forum shopping. This is why we move them from Mawego all the way to Nairobi. Your Honor, the offense that our clients were being investigated on was malicious damage to property. And now they are being charged with terrorism. So we can ask ourselves a simple question, Your Honor, that when was terrorism investigated? Because they were rearrested yesterday, reached Nairobi at night. Then in the morning were presented before you with a fictitious charge that has been baptized as terrorism. Your Honor, it can only mean that the courts, the law courts, the Oyugi's law courts were cheated, which is again serious disrespect I want to draw your attention and breathe more life to Article 50, Subarticle 2A. The doctrine of innocence. That one is innocent until proven otherwise. One is innocent until proven guilty. And therefore, as we have our clients before you, Your Honor, these are all innocent Kenyans, hustlers, innocent hustlers, innocent fishermen, innocent transporters of fish, and people. And therefore, Your Honor, the main reason for bail is for an accused person to attend court. That is the main reason, the fundamental, the basic reason is for one to attend court. And I refer to a case of Hilary Wachira, Wanjiku versus the Republic, 2020. Before your brother, Justice Kimaru, as it then was.
2020, which report?
GKLR. Justice said that bail is a matter of constitutional right, and the court should lean towards granting the accused bail pending trial, unless, put a rider to it, unless irrefutable compelling reasons are placed before court. But Your Honor, the alleged compelling reasons that are placed before you by the prosecution are surmise, conjecture, mere statements of path.
Just repeat it.
Therefore, Your Honor, our prayer is for you to consider as a parent, Your Honor, we consider the accused persons before you and admit them to a free bond because of the conditions that they are in. Your Honor, when I was talking to them, they told me that they've never come to Nairobi. This is the first time that they've been transported to Nairobi, just because they could not even afford fare from Homa Bay to Nairobi. Your Honor, these are people, innocent Kenyans, who earn between 200 to 500 shillings in a day. And therefore, Your Honor, even giving a higher bail to these innocent Kenyans will render the right to bail a nugatory. I rest my case, Your Honor. God bless you.